Okay. Justification for expectation damages. Rule reliance damages. So efficient breach. Here's some hypos. A agrees to sell B 10 custom-made laptops for $1,000 each on April 1st, so $10,000 total. C contacts A and says he desperately needs 10 custom laptops and is willing to pay $1,500 each, so $15,000 total. A sends the laptops he has to C and makes the extra $5,000. A builds another 10 custom laptops and ships them to B, but only on May 1st, not April 1st, like he said. B's losses, employees don't have what they need to work, total $2,000. How much should A have to pay B for the breach? And Helfand's answer was A pays B $2,000 because of the breach. So what is efficient breach? So this was an efficient breach for A because A made $5,000 more and he only lost $2,000 of that. So he still came out $3,000 ahead. So efficient breach? Yes, in this case it was. But does the efficient breach model account for all costs? Transaction costs, attorney's fees in the litigation, damages deemed unforeseeable or speculative, time spent working out the details, psychic harm and emotional distress for like my people can't work, reputational harm because my people can't work. Is the right person benefiting from the breach? Maybe B should share in the profits from A's sale to C. Is efficient breach a bad thing? Law and economic perspective. The discouragement principle. If you're going to make money off a breach, you should have to give that to the victim of the breach. We should have it to incentivize the breaching party to negotiate instead of breaching so we can have actual compensation. And courts rarely use so people do not know about it and do not organize their lives by this. Efficient breach. Roth v. Speck was our case here, and it's hard to figure out a comparison for this fantastic hairdresser. We don't know how much money they would have made at first and that the second guy sucks. So how much is he making at his new job? Using the discouragement principle, any new money you have made is going to go to the original employer who did not breach. By saying this, there would be incentive to negotiate. Lack of certainty makes expectation damages impossible. We should use discouragement in all cases of efficient breach. And then we have alternative to expectation damages, reliance and restitutionary damages, specific performance, and agreed remedies. Reliance. What I paid out, I want back. That's reliance. Restitution. What I lost and you gained, I want compensation for. Specific performance. Just do what you said you'd do. That's what I want. I want you to do what you said. Restatement 373, restitution when other party is in breach. Subject to the rule stated in subsection 2, on a breach by non-performance that gives rise to a claim for damages for total breach or on repudiation, the injured party is entitled to restitution for any benefit that he has conferred to the other party by way of part performance or reliance, not collecting on contract, just unjust enrichment already given. So I don't want everything that you promised. I just want what you've already taken. Other examples of when restitution is available. Contract is rendered unenforceable by statute of frauds. Fine. But you have a benefit and I want to be paid for the benefit that I conferred on you. Contract is avoidable on grounds of lack of capacity, mistake, misrepresentation, duress, undue influence. Contractual duties do not arise or are discharged as a result of impracticability of performance, frustration of purpose, or non-occurrence of condition. Then we have, this is the X-Rail steel erectors. This is about the cranes. And Algernon, Blair, I like Algernon better. That would have kept it in my brain. Algernon said they would do some work, and apparently no one figured out who was going to pay for the cranes, which was a significant cost, and both said no. And so Algernon was like, well, I'm not going to do it. We're not going to do it, because they would lose money on the actual contract if that was the case. So they breached. The expectation damages was 0 because they were going to lose money on the contract, but restitution, the reasonable value of services rendered. And they said reasonable value of services rendered is the amount for which such services could have been purchased from one in the plaintiff's position at the time and place the services were rendered. So if he had finished the contract, he would have lost money, but because he breached, he was able to collect in restitution, so he got paid for the services that he had already done, which is kind of crazy, and Helfand thinks it's crazy. So, but the market value rule of restitution, injured party makes more than had the breaching party performed. So breaching party should not end up in a better position. It is as if the contract does not exist. So that's pretty much what they said in this case. And then critics of market value restitution should not allow injured party to make more than had the breaching party performed. Restitution damages should not be more than expectation damages. Most courts apply market value restitution. Okay. So there are critics of the market value restitution, but most courts are going to apply it. Okay. Restatement 373, restitution when other party is in breach. Subject to the rule stated in subsection 2 on breach by non-performance that gives rise to a claim for damages for total breach or on repudiation, the injured party is entitled to restitution for any benefit that he has conferred on the other party by way of part performance or reliance. The injured party has no right to restitution if he has performed all of his duties under the contract and no performance by the other party remains due other than payment for the definite sum. So this is easy. You can't breach when the only thing left to do is pay and then say, like, no, the benefit I conferred was actually more, and so I'm suing for more. And you haven't tendered, so now I'm suing you because you haven't tendered, and now I'm looking for reliance. Restitution damages. It's not going to work. Comment B. Since he is entitled to recover the price in full together with interest, he has a remedy that protects his expectation interest by giving him the very thing that he was promised. To give him that right would impose on the court the burden of measuring the benefit in terms of money in spite of the fact that he has already been done by the parties themselves when they made their contract. So that's easy. When the only thing left to do is pay, you can't try to get restitution. You can't. Okay. Lancelotti v. Thomas. Can a breaching party still collect in restitution? The answer is yes. Old rule. Defaulting party could not collect in restitution. To allow recovery would invite contract breaking and reward morally unworthy conduct. But we don't look at it this way anymore. New rule, defaulting party can collect in restitution. Rules of contract law are not rules of punishment. The contract breaker is not an outlaw. Hypo, think Jacobs v. Young, which I keep saying Jacobi, so this is the house with the pipes, without substantial performance. I'll have to think on that one. I can't explain it. Restatement 374 says restitution in favor of party in breach. Subject to the rules stated in subsection 2, if a party justifiably refuses to perform on the grounds that his remaining duties of performance have been discharged by the other party's breach, the party in breach is entitled to restitution for any benefit that he has conferred by way of part performance or reliance in excess of the loss that he has caused by his own breach. So if he conferred more than he breached, he can get some money. To the extent that under the manifested assent of the parties, a party's performance is to be retained in the case of breach, that party is not entitled to restitution if the value of the performance as liquidated damages is reasonable in light of the anticipated or actual loss caused by the breach and the difficulties of proof of loss. Courts will not agree to penalty clauses. So this is the Ventura case, which is our wrestling case. In quantum merit is available in pre-bloom for the pre-bloom period. Yes. Benefit received by Titan beyond the good it contracted for. So they contracted for a wrestler and then they sold his videos. So Minnesota law would recognize the tort of violation of publicity rights, and there was no contract covering videotape distribution for publicity rights. So publicity made a benefit that Titan unjustly retained, and so Ventura got to collect on that benefit that was retained. Was it available post-bloom period? And again, the answer is yes. Although there is a contract, Titan misrepresented its policy to Ventura in order to induce Ventura to agree to not collecting royalties. So it was fraud and it was material. Did the district court abuse its discretion when it relied upon testimony from Ventura's damages expert? No, it was actually pretty good. Did the court err in denying Ventura's request for pre-filing interest? Yes, because the damages were not a defined amount, so interest can only be for defined amounts. And now lastly, we've got specific performance and agreed upon remedies, which I really like because it makes it so, well, I really like agreed remedies. Why not always specific performance? Well, you have expectation interest. What better way to provide benefit of the bargain? You give what's expected. You have reliance interest, and the pro of this is what better way to make sure people can rely on a contract. Then you have efficiency. The pros allows court to avoid complex damages calculations and avoids problems of transaction costs, but the con is parties would not be able to efficiently breach, which we already said they shouldn't do. That may have been an Austin comment. Moral reasons. Pro, have parties fulfilled their contractual promises? Con, something akin to servitude and forcing a party to act in a particular fashion. So specific performance, restatement 357.1. Subject to the rules stated in 359 and 6 through 69, specific performance of a contractual duty will be granted in the discretion of the court against a party who has committed or is threatening to commit the breach of duty. So, can happen. Restatement 359 says specific performance will not be ordered if damages would be adequate to protect the expectation interest of the injured party. But in practice, not really. When to apply specific performance. 360 says factors affecting adequacy of damages. In determining whether the remedy and damages would be adequate, the following circumstances are significant. The difficulty in proving damages with reasonable certainty. The difficulty of procuring a suitable substitute performance by means of money awards as damages. And the likelihood that an award of damage could not be collected. Situations where specific performance will not be applied. 362, effective uncertainty of terms. Specific performance or an injunction will not be granted unless the terms of the contract are sufficiently certain to provide a basis for an appropriate order. So contract must say exactly what's to be performed. Effect of difficulty in enforcement of supervision. A promise will not be specifically enforced if the character and magnitude of the performance would impose on the court burdens in enforcement or supervision that are disproportionate to the advantages to be gained from enforcement and to harm to be suffered from its denial. So the court doesn't want to be your babysitter. They'll do this for family court. That's where we do see this. But I don't think that's not contracts. So, but yeah, the court's like, hey, we'll decide, but like we don't want to be in the mix. City Stores v. Ammerman. This is the dream of the suburbs, as Zach would say. Specific performance, where damages are inadequate, that is they're unique, or they're real estate, where damages are impracticable, so the damages are uncertain. Courts will not order specific performance where supervision is too complex. Court sees no such difficulty in this Ammerman case. No specific performance if the hardship to the defendant is greater than the benefit to the plaintiff. But here the defendant has the ability to perform. They will simply lose the profits because they wanted to put Sears in there who they thought they would make more money from, which they probably did in the 80s and 90s, would have. And then the defendant is to blame for the current situation. It was the defendant who put it out there that like, you do this and I'll do this, and then they did not. So test for liquidated damages, and this is a factors test, and there are 3 factors. The damages to be anticipated from the breach must be certain in amount, Test for liquidated damages. The damages to be anticipated from the breach must be uncertain in amount or difficult to prove. The parties must have intended the clause to liquidate damages rather than operate as a penalty. Penalties are not going to be work. The amount set in the agreement must be reasonable forecast of just compensation from the harm flowing from the breach. So now we've moved into the Berry School case. And the question is, must the non-breaching party mitigate damages when the agreement between the parties contains a liquidated damages clause? And the answer is no in the majority. First, such a clause must provide in clear and unambiguous terms for a certain sum. Secondly, the liquidated damages must reasonably be compensation for the damage anticipated by the breach. Third, liquidated damages clauses are by their nature mandatory binding agreements before the fact, which may not be altered to correspond to the actual damages determined after the fact. And this goes for either side. Neither side can change them. Key points. The liquidated damages clause must be an approximation of damages at the time of contract formation. The purpose of enforcing the clause is to give effect to the intent of the parties. So those are the key points. Restatement 356, liquidated damages and penalties. Damages for breach by either party may be liquidated in the agreement, but only at an amount that is reasonable in light of the anticipated or actual loss caused by the breach and the difficulties of proof of loss. A term fixing unreasonably large liquidated damages is unenforceable on grounds of public policy as a penalty. So liquidated damages can't be a penalty, although all my life I thought they were. So comment B puts 2 factors. Reasonable in light of the anticipated or actual loss caused by the breach. This is fixed amount is reasonable to the extent that it approximates the actual loss that has resulted from the particular breach, even though it may not approximate the loss that might have been anticipated under other possible breaches, or approximates the loss anticipated at the time of the making of the contract, even though it may not approximate the actual loss. So it's all in foresight. Difficulty of proof of loss. The greater the difficulty either of proving that loss has occurred or establishing its amount with the requisite certainty, the easier it is to show the amount fixed was reasonable. So the more uncertainty, the better as far as liquidated damages. The dissent of Berry School said, you still need to mitigate damages even if there is a liquidated damages clause. You need to consider the liquidated damages provision also in light of the actual damages at the time of breach. If there is no actual damages at the time of breach because of the failure to mitigate, then liquidated damages clause is not reasonable and therefore is likely a penalty. But that is the dissent, so in an exam you'll want to go both ways and then say, well, the majority says no mitigation necessary. And that is that.